If you're curious about what a Rule 32 petition is, you've come to the right place, because I'm going to describe what a Rule 32 is and how it affects people who have been convicted of criminal offenses. When people stand in front of a judge and they're entering a plea agreement, the judge almost always will go through a very, very long process of asking a whole bunch of questions. And a lot of those questions are, do you understand what you're citing? Do you understand you're giving up your right to trial? Do you understand you're giving up your right to appeal? You understand that if anybody, I'm asking you as the defendant, has anybody forced you or threatened you to take a plea agreement? They're asking these questions because a plea agreement needs to be entered freely and voluntarily and knowingly. And many times people will sign a plea agreement without fully understanding exactly what the range of possibilities are. But the judge will then go over that plea agreement in great detail just to ensure that, all right, if the lawyer didn't go over it or if you have some misapprehension about what the plea agreement is, well, we're going to go over it now, and then so that's why change of plea can take 10 or 15 minutes. The judge is reading through this plea agreement to make sure that no one is forcing or coercing or threatening you to take the deal and that kind of thing. They also want to make sure that you're not on drugs, you're not impaired by some substance, and that you're doing so, you're entering this plea agreement knowingly. That's another factor that they're going to be looking at. A Rule 32 is extraordinarily limited. So if you enter a plea agreement, the only real outcome, the only real avenue of relief that you've got, you can't appeal it. You can just file a Rule 32. It's called post-conviction relief. And a Rule 32 is limited to whether or not a manifest injustice occurred. It's a very high standard. You got to prove that something really, really unusual happened in order to essentially reopen the books and start your case over. If you win a Rule 32 petition, you don't walk free. The case doesn't get thrown out. Actually, the case just starts all over again. That's another factor you need to consider. What are the judges going to be looking at? Whether or not the plea agreement was entered freely, voluntarily, knowingly. So if you entered the plea agreement and you were impaired by alcohol or drugs and you didn't understand it, that would be a grounds for a Rule 32. If you did not speak with your attorney at all before entering the plea agreement, that would be grounds for a 32, because it has to be read to you and explained to you. You can't just sign a document, walk into court, enter it without knowing what it is that you signed, especially for a felony offense. Those are grounds for Rule 32, but the judge still needs to basically they'll have to look at, so a judge has to look at your case and then determine, okay, was a manifest justice occurring here, and does that justify having the case completely reopened? So the fact that you signed a plea agreement, which is not totally desirable, the fact that the judge sentenced you to the very, very high end of the agreement, but you knew that that was a possibility, that is typically not going to get your case reopened on a 32. Just limited to whether or not you were threatened, forced, coerced, you didn't know what you were signing, and or there's some other very, very unusual set of circumstances that led to your entering a plea of guilty. So if you have any questions about a Rule 32 or post-conviction relief in Arizona, give us a call. 602-989-5000 is our number. I'm Nick Alcock with Alcock & Associates, and thanks so much.